the court didn't want to do that. They're not going to consider the assignment of errors in this case. I can give you this case and you can go through it. So his issue is raised two issues, both relating to the admissibility of evidence, testimony, a support enforcement specialist because it was hearsay. Oh, now this might be applicable to a lot of people. I don't know how they rule in this matter, but y'all see that?
Raises two issues, both relating to the admissibility of evidence. He contends the trial court erred in admitting the testimony of Michael Ribble, a support enforcement specialist with DCSE, because it was hearsay and Ribble lacked personal knowledge of the DCSE records and the appellee's testimony concerning the contents of the child support order and DCSE records because she was not the custodian of the records nor was the support order certified.
Now, Ribble testified he was the records custodian for DCSE and that he had printed out and was in possession of support payments accounting for in the instant case. Over appellant's hearsay objection, Ribble testified, meaning that the court overruled his objection to letting him testify. Ribble testified that DCSE had received no support payments from appellant since December 2008, a period of 8 months, and resulting in an arrears of this much. On cross-examination, he testified he had no personal knowledge of the contents of the documents he relied upon and did not know whether the figures were accurate. That could be important. However, he stated the documents were certified and kept in regular course of business. This right here is something that you'll hear from a whole lot of so-called witnesses or expert witnesses or what have you. They love to kind of stick that stuff in there. Why? I don't know. It's in there for whatever the reason is. So there you go. Let's see how they held. So that's important. So, there's rules and then there's exceptions to rules and then there's exceptions to the exceptions to the rules. It's inadmissible unless it falls within one of the recognized exceptions to the hearsay rule, and the party attempting to introduce a hearsay statement has the burden of showing that the statement falls within one of the exceptions. As a recognized exception to the hearsay rule, this court has adopted a modern shop book rule allowing, in given cases, the admission into evidence of verified regular entries without requiring proof from the original observers of the record keepers. So there you go. That's their standard there. Now, I know that may sound like it sucks, but that's their standard. And that's the reason for it. The truthworthiness or reliability of records is guaranteed by the regularity of their preparations and the fact that the records are relied upon in the transaction of business by the person or entities for which they are kept, and they are kept in the ordinary course of business made contemporaneously with the event by persons having a duty to keep the record. So even if it's improper, if they do it as the way that they take care of business, and I ain't got to tell you, Kyle, you've been in the military, and although I don't have anything disparaging about the military as far as to say necessarily, but we do know when you go from one unit to the next unit, sometimes you find out record keeping wasn't very good. But they could rely on the bad records. No, I wouldn't use the military as a good example, but say you work at some auto parts store, and the way that they do things is the way that they do things. They could come back and testify that, hey, this is how we keep these records. So the court is essentially like the court saying, we're going to construe that their record keeping is what they're saying is proper because they do that without you being able to necessarily parse it. So I'm almost positive that the court held in favor of the contempt.